afternoon. It is Thursday, May 27th, 2020. The
When?
time is, I'm sorry?
Wednesday.
Wednesday, thank you. Wednesday, May 27th, 2020. The time is 4:01 p.m. and I'd like to call to order the continuation of the May 7th, 2020 Board of Adjustment hearing, notice properly given. This meeting is being held electronically using the virtual meeting platform Zoom in an effort to comply with Governor Cooper's order to address the COVID-19 health emergency. We have a quorum with us today. Our permanent members who were at the original hearing are here for this continuation: Leo Santuaso, Joel Schreiber, Cindy Burnett, Jeremy Hooper, and myself, Julia Latham. As a housekeeping note, this procedure is being videotaped, so speaking clearly into your microphones is important for everyone here. I'll be proceeding a little more slowly and deliberately than we do when we're at the Village Hall in an effort to make sure that everyone has an opportunity to speak and to be heard. And once again, we ask that nobody use the Zoom chat function so that we keep everything transparent and in compliance with North Carolina law. At this time, I'm going to ask if we have a motion to exit the Board of Adjustment meeting and re-enter public hearing number 1 concerning the property at 10 Rockland Lane.
So moved.
Second.
Motion by Leo Santuaso, second by Cindy Burnett. All in favor?
Aye.
Aye. Opposed? All right, motion made and carried. We are entering the public hearing number 1 regarding the property at 10 Rockland Lane. At this time, I'd like to remind all of our witnesses with us today that you are still under oath from our prior meeting on the 7th. I'd like to ask Alex to please remind us of the facts of this application and to introduce any new evidence to be submitted into the record.
All right, gladly do that. Thank you. Right, so as we recall from the previous meeting, that we are receiving testimony and a variance request from section 9.28, tables of technical requirements for the property addressed at 10 Rockland Lane. During the previous section of the public hearing, the applicant and property owner Kirk Atkins did ask to modify or amend his request to allow now for a 25-foot setback. So it's from the previous 15-foot setback. Also within the previous meeting, the board decided to give the applicant the opportunity to pursue flipping the proposed site plan of the home on the lot to see if that it would fit within the applicable building envelopes such that a variance would not be required. So since then, Mr. Atkins has worked with his designer and his surveyor, and he has now shown and submitted new material for review and consideration of the Board of Adjustment. These new exhibits are labeled Exhibits Q through T and are named Flip Site Plan, Exhibit Q. Exhibit R is the flip site plan with additional measurements by the surveyor. Exhibit S will be the flipped building plans and elevations, and Exhibit T is a photo of the north side boundary marker. So at this point now, I will officially enter these items now into the record, and we'll turn it back over to you, Ms. Latham, and we can hear from the applicant.
Terrific, thank you, Alex. At this time, does anyone on the board have any questions for Alex regarding the new materials that have been entered into the record? Leo?
No.
No.
Jeremy?
No, ma'am.
Cindy?
No, I do not.
Okay, thank you very much. At this time, then, I'd like to call on Mr. Adkins. Mr. Adkins, thank you for being with us today. As a reminder, you're still under oath. Would you like to offer any additional testimony at this time regarding the new evidence that you've had entered into the record?
Yes, ma'am, I would, please. May I begin?
You're ready.
Okay. So before I begin, I'd like to just make two key points about this application. First, which Mr. Cameron just referred to, is that I've formally changed my original application from a 15-foot setback on the north property line to a 25-foot setback. So I'm only asking for 5 feet. And then second, I have listened to and acted upon the board's suggestion regarding flipping the house plan within the building envelope. And then after careful consideration with the surveyor, the designer, and the builder, we agree with the board that flipping the house plan generates at least 3 significant benefits, which I'll discuss shortly. Therefore, should this application be approved, I shall seek planning permission with a flipped house plan. So as this board will recall, I was asked if I would consider flipping the plan to determine if the flipped plan would fit within the building envelope. I have undertaken the expense of flipping the plan. So if you would please look at, Alex, or Mr. Cameron's already got it pulled up, Exhibit R. And then if you look at the proposed house location, and in the extreme northeast portion of that, you will see a surveyor notation that says that northeast corner is 26.57 feet away from the northern property line. So in other words, this plan still encroaches 3.43 feet. And then you can also see on this chart in the extreme northeast part or upper right-hand part of it, where it states that this building encroaches 32 square feet into the setback. And then you may recall, I don't know if we want to pull that previous non-flipped plan up, but there was 42 square feet of building space that was in that plan, and it encroached slightly more. Oh, you going to pull that up, Alex? Mr. Cameron? No? It doesn't really matter. So the original encroached 3.72 feet, whereas this one only encroaches 3.43 feet. The previous one encroached 42 square feet of building space. This one only encroaches 32 square feet of building space. And then I don't know if you would like to go into more details. I'm happy to do it if you'd like, but I spent a lot of time with the surveyor on this particular plan, and then we've given virtually every measurement that I think the board could wish to see on this flipped house plan. Is there anything that the board would like to discuss in terms of measurements or fitting on the envelope amount?
Mr. Atkins,
Yes, sir.
Leo Santawasso here.
Yes, sir.
That encroachment area that's shown as 32 square feet, I think somebody needs to check the math on that thing. It is a right triangle, 20.23 feet by 3.48 feet. And my slide rule says it's a total of 35.2 square feet rather than 32. That's for the record. I think that might need to be checked and corrected.
Okay, the only, because and I don't disagree, but I had the surveyor spend a lot of time on this, and that perhaps because of the slight angle that it's taking, that it changes.
I don't think it does.
Slightly, and the numbers
let's put that aside.
Okay.
Let's put that aside for a minute.
Okay.
I want to thank you for taking the time and effort to represent what things would look like with the house flipped. And you mentioned earlier that there were 2 or 3 benefits that you thought the flipped house would enhance this application. What were they, or what are they?
And I'd like to think that I could take credit for them, but the board, actually, you and Mr. Schreiber elucidated them in the previous meeting, but they were, first, that due to the driveway being further southward, safety is enhanced. So on the original driveway, it was actually coming out almost exactly where the current stop sign is on the corner of Rockland Lane and Doral Drive. So with the flipped plan, the driveway is a safer distance away from the stop sign.
So that's the safety consideration.
Yes, sir.
Thank you.
Yes, sir. Then the second benefit, and it was something that you all had referred to as well, is on the previous plan, we had the golf cart garage. So now if we could please, Mr. Cameron, if you could pull up Exhibit T. This is a picture looking from the center of my property, 10 Rockland Lane, looking southward to the neighbor at 20 Rockland Lane. And you can see it's not a very good picture, but on the right-hand side of that picture, you see a bunch of pine straw bales. There's actually a golf cart garage from the neighbor. And now when my property is flipped, it enhances the curb appeal. And I want to be very sensitive to the neighbor. And so I felt better about flipping it with the fact that the neighbor at 20 Rockland Lane also has a golf cart garage, and they'll be facing one another. So I don't feel like I'm unduly compromising their views. And then the third benefit, Mr. Santawasa, if we could look at Exhibit F, please, and then page 5 of 6. And perfect, that's it. And it's the left side elevation. And then one of the concerns, it seemed, with the board was when one approaches the house going south on Doral Drive, as one comes by the halfway house, you are going to see this house. And so this will be the predominant curb appeal. And then we've enhanced this by putting the cross beams in that gable and then making horizontal and vertical hardy plank board to make it more aesthetically pleasing. So those are the 3 benefits. And then there's some other benefits that are purely, and I think that has to do with the neighborhood, with safety, with my neighbors. And then there's other benefits that are purely attributable to the house, like better views. Mr. Schreiber talked about with the patio positioned the way it is, that you'll be able to see the 11th tee box and down the 11th fairway better. So there are better, there are more benefits associated with this flipped plan. So in conclusion, in preparing for this meeting, I spoke with Mr. Cameron. I was informed that all of the items that we discussed at the previous meeting are part of the record. So consequently, for the sake of brevity, I will not reiterate my hardships associated with not allowing this 5-foot relief on the north property line setback for which I seek. And that's really all of my comments for today. Thank you.
We had questions from Leo. Any other questions, Leo?
Not at this time.
Joel?
I'm sorry, is that me?
Yep. Any questions for Mr. Adkins?
Well, I just have a comment, and I don't know whether this is germane to this issue, but the applicant keeps referring to the board asked him to do this and change the way the house was constructed and add something on and curb appeal. I don't believe any of that was asked of him. I believe that we may have suggested to him that he do this to mitigate the concerns of his neighbors who have standing in this hearing. But I don't think any of us told him he needed to do this, suggested anything other than maybe he wanted to review what he had. I just want to make that point that we're not here to critique how the house is designed, where it's stationed on a piece of property. That's not our domain, I don't think.
So perhaps I used poor choice of words. I agree with you, Mr. Schreiber, that I voluntarily undertook to do this. So
Let me just interrupt you for a second. I'm sorry to do this, but I'm not doing this in criticism of you, but since this is a recorded hearing, I want to make sure that it doesn't go on record that we asked you to do something, because that is not within our guidelines. And I don't want to be on the record 5 years from today or whenever with somebody else bringing up, well, you did this for him, why don't you do it for me? That's all. I'm not being critical of you at all or your language. It's just a point I want to make from a legal standpoint. And I'm not a lawyer, Julie is.
Thanks. Cindy, any comments or questions?
I do have a comment because the neighbors brought up the fact that it would be a two-story building, and you know that most of the houses in the neighborhood were around 22 to 2,400 square feet. So I did a comparison on the GIS, Moore County GIS maps, and most of the lots are about the same, 0.28, 0.27 square acres. So the lot size is the same, and the building square footage runs from 2270 to 2410. And I included the corner lot across the street as well. But when I looked at the width and the depth of the buildings on the lots, on 10 Rockland, you know, the widest part of his house is 49 feet 7 inches. And most of the other houses are 1 story, but their width is between 61 to 69 inches, and their depth is from 61 to 79 feet, or feet, not inches, but feet. So there really is a bit of a hardship if he was to build a 1-story house on this property. It would be difficult for him to match the size of the other houses on the same acreage of lot, just because of that other 15 or 30 foot setback. So he has a 49 foot 7 inch wide house now. If he had 15 additional feet, he could go up to 64.7 feet, which is more in line with what the other houses on that street are. So I know it was a concern of the neighbors that it was going to be a 2-story building versus a 1-story, and that it would have more square footage than the other houses. But if he's forced to build a 2-story, you know, to get even, I mean, like right now he has 2,048 square feet on the first floor. So he really can't match the square footage on that amount of land that is dictated by the setbacks. So I just wanted to share that for consideration. But then again, he's got this building plan, so he may be set on that. So this may be a moot point.
Thank you, Cindy. Jeremy?
Yes, ma'am. Mr. Atkins, were there any other ideas or input that your home designer gave you, either with this plan or another, that would fit a home in the building envelope, or to make this one fit? Any adjustments?
No, sir.
Okay, so can you give me a little bit of an idea about the process when you went back to them? Did you just ask them to flip it? Was there any direction from you, or can you expand on maybe that process a little bit for me?
Yes, sir. So initially, the selection of this particular floor plan was done by selecting a house that had beautiful views facing the 10th green and the narrowest width that we could possibly find. And this was it. And then in terms of the process and thinking behind this flipped plan was we did talk about ways in which we could minimize its footprint. And then you're talking about doing an entire new plan.
Mhm.
And it was going to cost thousands of dollars to do that because this has cost over 5,000 to get me to where I am.
Sure.
And I did not think that that was a worthwhile expense.
Thank you, sir.
Yes, sir.
Julius Joel, I have one other comment.
Sure, go ahead.
If you can just, Alex, throw up on there the elevations of the building, of the house. Okay, so stop here for a second on each one of these, if you will. So when I look at this house, and I'm not making a judgment here, but just a statement, and Leo help me out with it. This isn't to me a two-story building. This is a building where you've made use of the, if you will, attic space to add rooms in the attic. Can you just flip to the other views for me? Okay, so I mean, this is the same thing. If you look at the roof line behind there, what he's done, I think, is not a typical two-story house. It's a house that's made use of some attic space. That's my only comment to it.
I would add that the appearance of this building is almost, I won't say the same as, but it's pretty much duplicated by the building directly across Doral from this lot.
Yeah.
That is also, I'll call it a story and a half. So representing this as a full two-story building, I don't think is out of character with the majority of the buildings in the area of Doral and Rockland.
I'll make a comment on that as well, if it's okay. Only an effort to give a response to the neighbors who showed a lot of concern in our first meeting. Is there a way that we can get the side elevations pulled back up again? So, you know, again, from the side, the design and again, this is only input that we can't consider for a variance. But if you look again, you see the softer roof lines over the second story. So that's going to provide a look coming around Doral that's not going to be like it's a big flat wall coming up for the second story and look like it's just a wall of windows. So that isn't a very appeasing second story and roof line. Just a comment to Mr. Atkins there.
Any other testimony for us at this time, Mr. Adkins?
No, ma'am.
I know that there are members of the public who joined us previously who I'm seeing on the call. And so I'm going to go ahead and remind you all at this time that you are also under oath and that the board is here to entertain competent, substantial, and material evidence that you have to offer to us. The information that you gave us previously in the first part of our hearing is already part of the record. So I would ask each of you to limit your evidence at this time to testimony that pertains to the new evidence that's been presented into the record. And with that, I'll go ahead and call on Mr. Derek Alty, if he's here with us today.
I am. Thank you, Ms. Latham, and I'll try and be quick, but I was hoping that that Alex and Leo and other members of the board could help me out and better understand the process the board must follow when it's considering variation application of this type. And I sort of begin with, you know, the basic proposition that the board's got to proceed on some kind of principled basis in considering this application. And I'll try and describe, my understanding of those principles and how they might apply in this particular circumstance. And as I said, I'm not really an expert on zoning matters, let alone, North Carolina zoning matters. So Alex was very helpful to me in providing, direction towards the Pinehurst Development Ordinance and what it does and doesn't say. But as I understand it, the development ordinance contains what it refers to as the minimum standards for the promotion of the protection of the public health, safety, and general welfare. That's the governing principle set out in the ordinance. So in effect, those are the minimum standards that are provided for in the ordinance. The applicant, Mr. Atkins, is asking you to relax those standards beyond what is the minimum standard required for the protection of the public, including the neighbors and other people who use and travel through Doral Woods. I think as Cindy noted, the applicant's lot is 0.28 of an acre or 12,377 square feet in total. That exceeds the 10,000 square feet, which is the minimum square footage for a lot in the R10 zoning district. So in other words, the applicant's lot could technically be 2,300 square feet smaller and still be compliant, such that he could build a home on the lot. Now, it seems to me I could stop there and conclude that that's enough in and of itself to dismiss the application. The square footage of his lot is larger than the minimum required square footage, yet the applicant is asking you to expand the boundaries of the lot by reducing the setbacks. The ordinance, as I understand it, goes on to say in section 5.11 that variances are to be granted by the board in those cases where the application or the strict application of the zoning requirement creates an unnecessary hardship, effectively prohibiting the use of the land in a manner otherwise allowed under the ordinance. And I think Alex was helpful to me in saying there's really no definition of what unnecessary hardship is in the ordinance, although there's other provisions of the ordinance that help give meaning to that particular phrase. So for example, the same provision elaborates by stating that a variance can't be granted merely to remove an inconvenience or a financial burden suffered by the applicant. Finally, the provision states that a variation is intended to provide relief where the zoning requirements of this ordinance render the land difficult or impossible to use because of some unique physical attribute of the property itself. So just to summarize for a minute what I understand to be the governing principles that guide the board in its consideration of this particular application. First, the board must determine that unnecessary hardship exists before the application to vary can be granted. Second, the board can't grant the application merely to remove an inconvenience or a financial burden. Third, the board must determine that the land is difficult or impossible to use because of some unique physical attribute of the property itself. And then finally, in applying the standard of review, the board can't grant the application where the unnecessary hardship results from personal circumstances. So if we take each of these governing principles one at a time and try to apply them to Mr. Atkins' application, I think we proceed as follows. So what is the unnecessary hardship that the application suggests exists? And the only answer seems to be that Mr. Atkins can't build a home on a lot that exceeds 3,000 square feet in size. It's not a house. He just can't build that he wants, and he can't build a house that large. I think it was Jeremy that posed the question to him. Had he, in consultation with his experts, home designers and otherwise, surveyors, had he determined that there was a home that could be built on that lot and respecting the setbacks? And what size of home would that be? And to take Cindy's point earlier, it may well be that a single-story home can't practically be built on that lot in a manner in keeping with the homes in the neighborhood. But that's not to say that a two-story, or as Leo put it, a story and a half, although I think it looks more like a two-story home, frankly. But leaving that aside for a moment, what the applicant hasn't put before the board is, can he build a two-story home and respect the setbacks and have a reasonable sized home? There's absolutely no evidence before the board that that can or cannot be done. And if that means that the home is not 3,500 square feet, but 3,200 square feet, that hardly seems like a hardship. That seems like no hardship at all. So that's the first principle. The second principle is that you cannot grant an application to merely remove an inconvenience or a financial burden. And in this case, Mr. Atkins is effectively suggesting that it's inconvenient that he can't build a home this large. And that, correspondingly, it would ultimately impact the selling price of the home. But neither of those two factors are justifications for granting the variance application. In fact, the law prohibits you from granting the application if you're just removing an inconvenience or a financial burden. Third, you must determine that the land is difficult or impossible to use because there's something physically unique about the particular property. There's absolutely no evidence before the board that it's difficult or impossible to use the land for its intended purpose. The only evidence before the board is that the applicant can't fit a home that's larger than 3,000 square feet on this particular lot. There's no evidence he can't fit some home on the lot. In fact, he couldn't provide an answer to Jeremy's question. He didn't even consider whether there was a home of this particular type, slightly smaller, that could be built on that lot and respect the existing setbacks. There's absolutely no evidence before the board that it's impossible or difficult to build a home on this lot. He just can't build a home as big as he wants to build a home. And then finally, you can't grant this application where the unnecessary hardship results from personal circumstances. And I know from listening to Leo and to Jeremy and others that you folks are experienced and you're knowledgeable. And I'm 100% confident in this case that you know precisely what is at play here. And that is to say, the applicant purchased the lot with the intent of building a 3,000 square foot home on the lot, but not to occupy the home as his primary residence, but rather to sell the home for a profit. We all know that. You guys know that. I know that. We all know that. So the only circumstances that are at play here are the applicant's personal financial circumstances. And that is to say, his desire to profit from the sale of a home. And that in and of itself can't justify granting the application. So let me just finish up by asking you a simple question. Let's assume you don't grant the applicant's variation application. What do you think is actually going to happen? One of two or three things. He'll either sell the lot realizing he can't build the home he wishes to build on that lot, or far more likely, he'll go back, find a home of a decent size that fits on that lot and build that home without ever seeking a further application for your board, before your board. You know that that's what's going to happen. He'll simply go back to the drawing board and say, fair enough. I'll build a story and a half. It'll be a slightly smaller home, similar to what you see in front of you today. It'll fit on that lot, and there'll be no more need to deal with this matter. You know that that's what's going to happen.
Mr.
Either that,
Alty?
you'll sell the lot and
Mr.
say,
Alty?
I can't build a home on this lot of the size that I want.
Mr. Alty,
That's all I got. That's it. Thank you, Ms. Latham. Sorry to take up your time.
Okay, and I just want to remind our other folks who are testifying and our board as well, that what we are able to consider is evidence that is substantial and material. We are not allowed to take into consideration opinion testimony. We appreciate the thoughts that you have, and we want everyone to feel heard, but we are limited in what we are allowed to consider when we make our judgments on these matters. I'm going to now ask our board, does anyone have questions for Mr. Alty?
I've just got one question, and it may be just diametric to what you just said, but I'd like to just ask him a question.
Go ahead, Joel.
If the applicant were to build a true two-story building on that piece of property, and when I say 2 floors, I mean 2 real floors with a real roof on it, and it was 3,500 square feet, and he didn't ask for what is less than a 4-foot variance to the planning and zoning requirements, would you still be before us?
Are you asking me that question? You're asking the applicant that question?
No, I'm asking you that question because I'm just curious as to what your concerns are. I mean, if you're concerned, then that's my question. So let me just rephrase it again to you. He loses here, and other than contrary to what you just said he might do, he might go back now and build a true 2-story building. So 2 floors, 9 feet per floor plus a roof, confine it to the PDO setbacks. Would you be happy with that?
Well, the only thing I can say to that, that's a good question. The only thing I can say in answer to that question is 2 things. To the extent that he comes back with a plan that, is faithful to the setbacks, there's not much we can say as his neighbors about that, A. And B, as I understand it from Alex, there's a minimum, or I don't know how to phrase it, maximum height requirement, I think, of 35 feet, as I recall. That seems to be pretty important. And so I'm not sure if your suggested 2-story building, is higher than 35 feet or lower than 35 feet. But as you know, Doral Drive and Rockland.
Okay, let me interrupt you here because I don't want to make this.
Sure.
So let me restate my question to you, and I think it's a yes or no. He brings back to planning and zoning because it has nothing to do with the Board of Appeals or the Planning and Zoning Board.
Right.
He brings back a plan that is 2.5 stories, 35 feet or less, without infringing on this 4-foot setback he wants. So now across the street from whoever is across the street from him, you got a 35-foot building that fits within the setbacks, 2.5 stories high. Would you still be here? Yes or no?
No, I mean, because you wouldn't be here, as I understand it. There'd be no, there'd be no basis.
You'd be happy with that building.
I would not be happy with it, but there'd be nothing I could do about it, and nothing you could do about it. With nothing either one of us could do about it. I mean, he's compliant. End of story. Do I want a 2-story home across the street from me that is not in keeping with the neighborhood, that he doesn't intend to live in, that is likely, relatively expensive in the middle of a pandemic and a depression? And no, I don't. But there's nothing I can do about it.
Okay, I just wanted to suggest to you what the alternatives might be, that there is a 4th alternative for him, and that is build a larger home, recoup his money from the land, and make all of you unhappy. I'm done.
Yeah, well, assuming that he's compliant, right?
I'm going to go ahead and move us along. Is there anyone else on the board who has any questions for Mr. Alty? Okay, thank you. At this time, is Mr. Vince, I'm going to pronounce it wrong again, and I apologize, Powerski available? Alex? Do we believe he's with us?
He did not join us.
All right, thank you. Mr. Jim Planker? Is he with us, Alex? Oh, okay. I'll give him a moment to, there you are,
Yeah,
Mr. Planker.
I should be unmuted now.
Terrific, thank you. Just as a reminder that you're under oath, and we are looking to you for competent, substantial, and material testimony this afternoon relative to the new evidence that's been submitted.
All right. I can make my testimony fairly short this afternoon because everything that Mr. Alfie said is within my notes. So thanks, Derek, for the for the assistance there. I do have one other thing to point out. Mr. Adkins very adroitly skipped talking about his hardship that he had in the application. He used dimensions that he derived from the GIS map to indicate that his neighbor to the south is situated 6.77 feet from the owner's south property line, and that the other homes on Rockland Lane are all situated within 7 feet of their north property line. That information is incorrect or false and should be stricken from the application. That's, I expect that the board would do that to make sure that the legal record is straight. That's all I have this afternoon. And by the way, I do object to or oppose the application.
Thank you. Does anyone on the board have any questions for Mr. Planker at this time? Okay, thank you. Next, Ms. Peggy Rainey, are you with us? Oh, you're muted, Ms. Rainey.
Oh,
There you go.
okay. Well, here again, I will just, I've listened to you this afternoon. I would just go back to the same thing that I said at the first meeting, in that this is, to me, an extremely big home, large home for that particular lot in the neighborhood. And I do think that it's, I don't think it's going to look all that well, but if this is what this gentleman wants to put on the lot, is a great big house, then I suppose he's within his rights to do that, and we have to live with it. I think that when you start changing up a neighborhood like ours with these extra large homes and so on, it takes away from our particular neighborhood. I know there are a lot of people in Pinehurst that love the big homes and so on. And that's great, because everybody has to have a choice. But I feel like that on that particular corner, it's not going to look well. Thank you.
Thank you very much. Does anyone on the board have any questions for Ms. Rainey at this time? Okay, great. Alex, can you let me know, is there, I don't see anyone, but is there anyone else who indicated they wanted to call into this meeting? Have we got anyone else joining us?
No more.
Okay, all right, great. Well, then I'm going to leave open the hearing while we have our discussion, so the board can direct any comments to the witnesses. But I'm going to let the witnesses know that this is a time for the board to deliberate, ask each other questions, and that's what we'll be doing now. And we may direct questions directly to you, but please direct your answer directly back to the board. So let's start with the, there's an evidentiary issue ahead of before us, and that is with regard to Exhibit O. That's the hearsay evidence from Mr. Farron. It's hearsay evidence because Mr. Farron is not present to authenticate it. state law requires that the evidence appear to be sufficiently trustworthy and admitted under such circumstances that it was reasonable that the decision-making board can rely on it. In regard to hearsay evidence, generally a person must be present for their evidence to be entered in, but North Carolina courts have allowed special cases for technical reports by experts. In this case, we have allowed similar letters to Mr. Bob Farron to be entered as expert testimony. I have no objection to allowing Mr. Farron's record letter into the record. Are there any objections raised by the board?
No, ma'am.
Okay, so at this time, we are going to consider Exhibit O properly within the record. Is there any other discussion about the application before us?
Julie, I just have one question for the applicant.
Yeah.
Have you discussed with Bob Farron the possibility of him either deeding you or allowing you use of that property? I know he's done this in the past, so that you don't have to apply for a variance.
No, sir, I have not specifically asked him that question.
Okay, thank you.
Mr. Atkins, would you like to restate your hardships for the state of the record with this new drawing and new plan that you've presented?
Yes, ma'am, if you would like for me to. So I feel like there are 4 different hardships. Number 1, the property is unique in that it has 3 sides of 30-foot setbacks. These 3 sides of 30-foot setbacks create a building envelope on which a house of the width of approximately 49 feet, 45 foot, I should say, could be built. And my house is 49 feet. If the variance were not granted, the building envelope would mandate a house to be constructed that would be incongruent with the style of homes in the neighborhood, very much as you had said, Ms. Burnett, that the other homes are 61 to 69 foot. Mine is only 49 foot wide, even giving this 3.43 foot encroachment that I'm asking for. And so I think asking for a home of that narrow width would not be maintaining the aesthetics of the neighborhood. The second point, second hardship is that this lot is the last lot to the north of Brockham Lane. There is no neighbor to the north. All of the land to the north up to the halfway house is owned by Pinehurst Resort. You have the letter from Mr. Farron stating that he has no objection with this encroachment. So there's not going to be any neighbor there on the north property line that would be impacted by the granting of this variance. The hardship has not occurred due to any actions undertaken by me. The lot is only 12,377 square feet, taking out the incremental 15-foot setback on the northern property, the incremental, because it should be 15 foot. So now it's 30, and I'm only asking for 25. The design of the house that is appropriate for this neighborhood in a favored location overlooking the 10th green cannot be built on the current building envelope. And then the fourth and final is the north border of the lot for which the setback variance is requested is not in the golf course field of play. The north border of the lot is past the end of the 10th green on course number 1. And it is 184 feet away from the halfway house. And then the golf course turns away from my property. the 11th tee box and the 11th hole goes diametrically the opposite way. Consequently, the variance request is within the spirit, purpose, and intent of the ordinance in that there is no impact on public safety. And so those are my 4 hardships.
Thank you. I appreciate you repeating those.
Yes, ma'am.
This time, then do I have a motion to close the public hearing and re-enter our regular Board of Adjustment meeting?
Second.
I'm sorry, who was that?
I thought somebody already made the motion and I seconded it. If
I
not,
don't,
a motion,
no, I didn't. We need a motion.
I will do so.
Okay, we have a motion.
Period.
Okay, we have a motion from Leo. Do I hear a second?
I'll second.
Thank you. I have a motion from Leo to recess the public hearing and move into our regular Board of Adjustment meeting. It has been seconded by Jeremy. All in favor?
Aye.
Aye. Opposed? Okay, at this time, we are closing the public hearing and have re-entered our Board of Adjustment meeting. We are considering today a request to vary the 30-foot minimum golf course setback from a property line in the R10 zoning district to allow for a 25-foot minimum golf course setback on the left sideline abutting the golf course. Did I get that right, Alex?
Yes, the request is now for a 25-foot setback.
Okay, great. Any discussion by the board, amongst the board at this time?
Well, let me start off and hopefully try to make sense of what's by the applicant and the adjoining property owners. First of all, I don't think the building as represented on the drawings submitted in evidence are out of line with the look, the size, or the character of other buildings within the neighborhood. And I'll go so far as to say that the Doral neighborhood includes more area than I'm looking at to consider for this neighborhood, which I'll say includes the Rockland and Doral Road. I'll call it Circle. There are several other 2-story buildings in the area within the neighborhood. And long story short, the building, I believe, is in keeping with the general character of the neighborhood. In flipping the footprint, I was hoping that it would not create a variance, but the application has been amended to now require a 25-foot setback rather than a 15-foot setback. And the amount of encroachment by the northeast building corner amounts to 35.2 square feet, which in my opinion is a de minimis encroachment. The actual dimension has been mentioned as 3.43 feet, but the latest drawing revised as of May 8th, 2020 with the mirrored house shows that dimension to be 3.48 feet. And the record should be corrected to reflect that. I believe that the 3 benefits that Mr. Adkins mentioned at the beginning with respect to flipping the house footprint moves the driveway further away from the intersection of Doral and Rockland. That is certainly a safety benefit, in my opinion. The left side elevation of the flip building presents a better appearance, especially the view from Doral Road. And putting the covered porch in the northeast corner presents an opportunity to enjoy more vistas from almost all directions, except from the direct south, out toward the golf course, east, north, northwest, and opens up an area for better view shed. Again, sure, a house could be built on this lot, but the golf course setback does present problems. Additionally, the curvature in the road indicates that you don't have a square to work with or a rectangle to work with, and it would take a building such as this designed to fit setback requirements. But again, the 25-foot setback requirement request, in my opinion, satisfies the hardship requirements, and I can go through them, but I'd like to hear first from other members of the board as to their opinions and any questions that they may have that with regard to the process I just went through.
I agree with you, Leo. I think Mr. Atkins has made an effort to fit a house within the setbacks, and 3 30-foot setbacks is unusual, as well as the curve in the road. And, you know, the other homes on that street are wider than his home is allowed to be. You know, 3 feet, a 5-foot setback or modification to the setback on the side that doesn't face the golf course, doesn't come into play with the golf course. I mean, the 30-foot setback for safety along the golf course is not going to be an issue on this side of his property. So I agree with what you're saying, Leo.
Jeremy?
So I'll share a couple opinions and then I'll get into my overall thought on the application. So of course my opinion is that it's a very low impact, low effect variance on the neighborhood. It's certainly minimal when we're speaking about 5 feet in the encroachment. So we do have a 30-foot golf cart or a 30-foot setback on 3 sides of the lot. We do have a curvature in front of the road. But otherwise, the topography of the lot's very flat, which gives a lot of flexibility to the building envelope that's left. You know, the hard part is I think that Mr. Atkins is certainly coming from the right place. And so I think he's made an effort, and I think that I hope regardless of what happens here today that he builds on the lot. I really do believe that, to Leo's point, that it'll fit quite well into the neighborhood. Otherwise, other than it being a new home, other than it having newer styles, I think it'll fit well. So I think to answer the neighbors with their concerns, you know, I hope Mr. Atkins builds on the lot, because I think we should really be afraid of the builder who purchases or would have purchased this lot and never asked for the variance. So again, that's my feeling. And, but again, we don't okay this on Jeremy's feelings. So when I look at it, and I look at it from that perspective, here in Pinehurst, we have a lot of unique lots, and thus we have a lot of unique house plans, and we have a unique process to building or to designing the house plans to fit on unique lots. And so it's my opinion that a house could be put on this lot with the correct design and taking that into effect. And so that's my concerns, is really connecting and justifying the hardships. I agree with the reasonings. I actually agree that they are all pertinent points. However, again, I'm struggling connecting the true hardship upon Mr. Atkins performing the house or building the house on the lot, given some of the facts that we've discussed. So, you know, as a board, I'm looking to hear back from us as a group, possibly how to connect those hardships and maybe being clear on what those hardships are.
I don't know whether now we want to go to Joel and Joel's comments, or whether as a group we'd like to discuss Jeremy's request to help him tie the clear, sort of unusual and unique features of this lot to the hardship element that we need to have as a threshold issue if approaching a variance. Joel, would you like to hold off on your comments while we address Jeremy's question, or how would you like to proceed?
Said, are you addressing that to me, Julie?
I am.
I'm about deaf. So,
I am.
yeah. Let me, I guess I might be coming from a different point of view. I asked my question of the first gentleman, and I don't like cliches, but I think you got to be careful what you wish for sometimes.
Right.
And so let me just give this gentleman the one. I forget his name, and I apologize. What was it? The first guy, first gentleman,
Alty.
Mr.
Alty.
Alty. So I'll just offer you my thoughts, similar to what Jeremy did. Your worst case scenario here is the applicant doesn't get the variance. He sells a lot to recoup his investment. He sells it to a builder who has an in-house design department, who now understands he's got to put X number of square feet up, and he builds I'll give you 9-foot ceilings with the joists, et cetera. He builds a house within the PDO. It's less than 35 feet. It conforms with the setbacks. And now you really got an atrocity in the neighborhood. I don't think the applicant is trying to do that. I agree with Jeremy. I agree with all of you that what it seems to me he's trying to do is build a quality looking home in a neighborhood in keeping with the other homes. But again, my concern is, and this may be a little unusual, in trying to protect the other homeowners in the area from themselves here. I can easily see with the dearth of vacant property, not just in Doral, but this close to the golf course, a developer picking this up and doing exactly what I said. And so that's my only concern.
Well, can I refocus us, and I think it's a good exercise, to Jeremy's question, which was how do these unique elements that Mr. Atkins has put before us, the 30-foot setbacks on 3 sides, the curvature in the road, what Cindy's pointed out with the limitation of the width of the house, how do we connect those to a hardship? Because as Jeremy is pointing out, and Joel in a way is reiterating, is, you know, hey, a house can be built in this lot. Is perhaps the hardship that it's, and I'm throwing this out here for you all to bounce around, is perhaps the hardship, the fact that there are these limitations on this particular piece of property. And if he goes forward and builds a house within those limitations, he very well may end up building something that is no longer in accordance with the neighborhood. This reminds me in a way when we were discussing, if you'll recall, there was the variance application over in number 7, and a gentleman was looking to build on a vacant lot. And if he stayed within the envelope, he was going to have to build a 2-story home. And there are no 2-story homes on that street in number 7. And it was our goal to help him create a house that was in accordance with the neighborhood. I'm wondering if you all remember that case, is this something that is similar? I know we're not bound by precedent. Every case is its own unique thing. But I'm wondering if that discussion doesn't resonate here.
I remember the discussion, yeah.
Leo, does this feel at all similar to you where a hardship argument could be made out of that information?
I think a hardship could be made for this application for this specific building design, for this specific property, being a corner lot in effect with anything but straight lines that define an irregular building envelope that will not contain the total footprint of a house that this applicant proposes to put on it. Now, that relates, I think, to an unnecessary hardship because of the building setback that is required for 30 feet for the golf course setback.
One thing that I'd like to propose that we think about, if indeed a motion is going to be made to approve this application, as you know, we are able to put conditions on approvals. And I think that perhaps a condition that we might want to entertain is limiting the applicant to this particular floor plan and the dimensions of encroachment. So we're not handing Mr. Adkins carte blanche to go build a 2-foot square, 2-story square with 25-foot setbacks on this property. Instead, we are asking him to build this house with all the benefits that he's already elucidated, with the view planes, the golf cart door headed, face a particular direction, et cetera, et cetera. So
I intend to stipulate that condition
okay.
if we get that far.
I would also like to add that, the ordinances are not to punish the owner of a piece of property. And it's unusual for the ordinances to require that so much of a lot not be built upon. And, and I think that the setbacks are for the safety of the homeowner and the safety of other people around. We don't want golfers breaking windows because the house is right in play. And this is this lot, it puts a hardship on the owner of the land when the ordinances restrict the building area to, yes, he could build a house there, but he couldn't build the neighbor's house on that lot because he doesn't have the width. So there's, I don't think the ordinances are meant to restrict a homeowner so much so that they can't build the house they want within reason. And I think this house that he has proposed is very considerate of the setbacks and is, within reason. So.
Julie, just let me, if I can, just piggyback on your comments here. The property to me is unique, and in the 30-foot setbacks, but the main thing is that's not a golf course on the left side of what he's proposing. That's a piece of property that's owned by Pinehurst CC, and they can't call it anything else. And so they've called it a golf course. Again, I've played golf there hundreds of times. I got to tell you, I thought it was a vacant lot that they are claiming as a golf course. It's just not a golf course. I mean, if I hit my ball up there, I don't know what I do with it, but there's no way that that piece of property next to this piece of property can be logically considered a golf course. And that to me is a hardship based on the fact that, or the observation that because you call it a golf course doesn't make it a golf course.
Well, if there's no argument from the members of the board at this time, then I'm just going to remind us of our standards of review. We've heard them a few times today, so I won't belabor them. But that unnecessary hardship must result from strict application of the ordinance. However, it shall not be necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. The hardship results from conditions that are particular to the property, such as location, size, and topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common in the neighborhood or the general public, may not be taken into account. The hardship did not result from actions of the applicant, and that the requested variance is consistent with the spirit, purpose, and intent of the ordinance, and that public safety is secured and substantial justice is achieved. We have several options at this time. We can deny the variance, approve the variance with conditions, and continue the meeting to another date for determination. I'll remind you that in order for the variance to carry, it requires 4 votes of the board. And I ask if anyone's going to make a motion to please use the format suggested by staff to aid them in creating the findings of fact for our determination. At this time, I'm going to ask, does anyone have a motion regarding this application for variance? Leo, did you want to?
What did you say? I didn't understand you.
I was asking if you wanted to make a motion.
Oh, yeah, I will. I do. I would move that this variance application be approved, and that unnecessary hardship does result from the strict application of the ordinance due to the fact of the 30-foot side yard golf course setback. The hardship results from conditions that are peculiar to the property with respect to being a corner lot on a curvature in the road that creates lot lines that affect the setback requirements that are irregular. The hardship exists and did not result from actions taken by the applicant or the property owner. The hardship is created by zoning restrictions which were created and have existed for many years. And we have had many applications in this regard that requested variances that were greater in magnitude than this particular application involves. And in my opinion, the requested variance is consistent with the spirit, purpose, and intent of the ordinance, as such that public safety is secured and substantial justice is achieved. The requested variance is consistent because it will permit a dwelling to be constructed in a manner and in keeping with the general character of the neighborhood, moving the driveway further away from the intersection of the Rowell and Rockland, promotes safety. Flipping the building footprint presents a more pleasing appearance from the north side of the building that people will see when they're on Doral, and places a covered porch on the northeast corner of the building, which provides better vistas for the property owner to enjoy the location on the site. I would, however, add condition. I guess there's 2 conditions that I'm thinking about. First of all, the encroachment area that's represented on revised drawing dated May 8th, 2020 as 32 feet should be corrected to read 35.2 feet. and that this house plan and footprint especially be mandated as part of the requirement to construct in the event that this application is approved.
Julie, can I ask Leo if he would consider an addition to that?
Well, what we can do, correct me if I'm wrong, Alex, is if there is a second to Leo's, would it be more appropriate to have Joel amend Leo's motion or ask Leo to consider an addition at this time, since we haven't seconded Alex?
I think somebody should second it, and then there'd be a discussion about amendment.
Amending, okay.
Agreed.
Okay, at this time, would anyone second Leo's motion?
I will second it. And this is for the 25-foot setback, correct?
Revised application.
Revised application, okay.
Okay, it sounds like we have a motion that's been made and seconded. Joel, it sounds like you would like to suggest an amendment to the motion.
Yeah, I'd like you, Leo, to think about that now that we've gone all through this and the applicant has expressed all of his desires and concerns, that he doesn't flip this house or flip this property and have somebody else put this home on it. And we've gone through all this to enable him to make a profit. So I guess what I'm saying is that to add to your restriction that the applicant needs to be the builder of this, we're issuing this approval for the house to be built, this house to be built by this property owner.
I don't think that's how it works, Joel. I believe the variance runs with the land.
Okay, that's fine.
Correct me if I'm wrong. And so no matter who builds the house, they would have to contend with the decision as made and seconded and recorded.
So does that mean, Leo, that they would have to build it in accordance with what you said? They'd have to build this house?
I said the footprint, not necessarily the house.
Can I offer some points of discussion on the motion?
Yes, please.
I don't necessarily think the previous condition, the first condition that Leo made, I am obviously not a licensed professional land surveyor here in the state of North Carolina, nor am I a licensed professional engineer. But if a setback were to be granted as this request of a 25-foot setback, the actual measurement of the total square footage of the house that would be within that encroachment, I don't think it's really relative to granting or at this point worthy of a condition or really relevant if the setback were to be granted. It just seems to be you got a 25-foot setback unless you're going to condition that. Well, then only a certain amount of square footage could be allowed to encroach within it. If there's any discrepancy within Leo's measurements versus what is prepared by the surveyor here with the submitted material, I don't think it's really worthy of a condition. But that's for you guys to decide. And Leo, I wanted to make sure we captured your first reasons for unnecessary hardship. I just want to make sure we got that clear. You said that it does result because of the applicable 30-foot golf course setback. I want to make sure that that's clear, that that's what you stated, or there's something you want to expand on for that. And that your other condition, as you just stated with conversation with Joel, is just for this footprint that's on the table right now, not for the entire design. I just want to make sure we get those clarified too.
Alex, can I ask Alex a question?
Let me try to answer his questions to me. First of all, I'll accept the elimination of the 35.2 square feet and go with the 25-foot setback. And the unnecessary hardship on the first condition is the 30-foot golf course setback.
Might I suggest if we're
Did that answer your questions, Alex?
Yes, it did. Thank you.
might I suggest if we're amending the motion, Leo, that you entertain that the hardship isn't just the 30-foot golf course setback, but the fact that this particular property has 3 30-foot golf course setbacks, limiting the width of the building to, what did you say it was, Cindy? How many feet?
I don't know the width of the building.
No, no, not the width of the building.
49.7 is the building currently,
49.7.
or 49 feet, 7 inches. I'm sorry, 49 feet, 7 inches.
So I would suggest that, you know, the hardship here isn't just the 30-foot setback on that side of the property, but rather the fact that Mr. Adkins is looking at 3 30-foot setbacks, limiting the buildable frontage of the property to 49 feet, 7 inches.
Agreed.
I like that.
However, just one point on that. I believe the buildable setback's more like 45 feet. To your point, I think 49 feet is the current width of the house as drawn.
Oh, so 45?
So we may need to look at a little more detail to your point, but I believe currently the building envelope in the rear is smaller than, it's obviously smaller than the 49-foot width of the house.
Okay.
So it's just, if I'm hearing your point correctly.
Yes, you are.
Okay.
That's why they want the setback, or
Which is
the
correct. This is why they
modified
want
setback, because of the back.
right, because it cannot fit the 49-foot width of the house as drawn.
Right.
Thank you, Jeremy. That's good.
I have a question for Alex.
Alex, Joel's got a question for you.
Can we stipulate that this home is what we're approving to be built on this lot?
And so let me just make sure I understand. So basically, this design that was submitted with this material package that you guys have, correct?
Yeah, with you know, some minor changes, but essentially this is the home that's going to go in there, because I've got some concerns for the people that live in the village. I don't want this thing to, now we've approved it, now you get your 2-story 35-foot high building on this, and we've approved this because of what it looks like and that it fits into the neighborhood, et cetera. I mean, that's part of our discussion. I just want to make sure that's what gets built.
But as you mentioned, there's been a lot of discussion on character,
Yes.
especially within the neighborhood. So I do think that could be a condition that would be relative to this request. Of course, that's up for the board to decide. And just for procedurally moving forward, if the board does want to entertain or move forward and amend the application that's now on the table, if we could have a motion to amend and state the amendment and then have a second on that, just procedurally.
You don't mean application, you mean motion.
Yes.
Okay.
Before we get there, can we include the statement that the building has to comply with the foundation plan as shown on Exhibit S, sheet 1 of 6?
I don't think they can do that.
To whom was that question directed, Leo?
Pardon?
To whom was that question directed?
Can we stipulate that
I know.
condition?
I know, who are you asking? Are you asking Alex or?
I'm
me?
asking Alex.
Alex, okay.
All right, so I think that can easily be handled with revising the one condition that you made about that the house plan or footprint that's submitted with the application be used. You can just expand on that as shown on Exhibit S page, or as shown in the foundation
Exhibit-
plan with Exhibit S.
Exhibit S, sheet 1 of 6.
That's certainly the motion could definitely be amended to include a condition stated like Leo just mentioned.
Okay,
Thank you.
and Leo, if you want to amend your motion, I'm going to ask you to walk us through it again, so we're all on the same page. I'm so sorry, I know, but just to make sure we're all on the same page.
And Julia, I was just recently reminded too, another option could be to vote down the motion that's on the table at this point and start anew.
Would we need to do that, or can we just amend and move forward? I'm happy to go either way.
It's definitely the choice of the board.
Leo, how would you like to proceed? Do you want to amend, or would you like us to vote down the first motion and start over?
Let's vote down the first motion and try to get through it again.
Okay, there is a motion on the floor that has been made by Mr. Leo Sanawaso and seconded by Cindy Burnett. I'm going to do a voice count. Where am I? Jeremy,
No.
Cindy,
Since I seconded it, can I still say no?
no.
No.
Mind after this excellent discussion. Joel,
If you say no, you're voting to vote down this motion?
vote down Leo's first motion, and I have the feeling that Leo would like to propose a second motion. We are
Okay, that's
voting
what
down the first
that's
section,
what
but
I'd
we're
like to
not
do.
denying the variance.
Okay, that's what I'd like to do.
Okay, thank you. Leo?
No.
Myself, no. Okay, that motion has failed. Is there another motion that anyone on the board would like to bring forward at this time?
All right, where do I start?
Start with hardship, because we talked about amending your motion regarding hardship, the three sides and the limited frontage of the lot.
And Leo, you can just start, just like it's a Brent, you make a motion to, and follow the draft decision letter to help you out, that you make a motion to approve or deny the variance request at 10 Rockland Lane, and then just use your decision letter to kind of help step you through.
All right. I move that this application be approved with the reasons associated therewith, that the unnecessary hardship would result because of the golf course setbacks on two sides of the property. That the hardship results from conditions that are peculiar to the property, such that this is a corner lot that does not permit regular setbacks due to the curvature of the road across the frontage and the two golf course setbacks. The hardship did not result from actions taken by the applicant, but were created by the existing zoning restrictions that have been in place for many years, and that the requested variance is consistent with the spirit and purpose and intent of the ordinance, because it will permit a dwelling to be constructed which is in keeping with the general character of the neighborhood. Moving the driveway further away from the intersection promotes safety, and flipping the building footprint presents a more pleasing north side of appearance viewed from Doral Road and places the covered porch on the northeast corner of the building, providing better vistas in all directions. Condition that the building footprint comply with Exhibit S, sheet 1 of 6, as submitted with the revised application, showing a latest date of April 1st, 2020.
The motion has been made by Leo Santarosa. Would anyone care to second this motion?
I'll second the motion.
Leo's made by, Leo. Motion has been made by Leo, seconded by Joel. I'm going to go ahead and do a poll for our vote, starting with Cindy. Cindy, how do you vote?
You're going to have a discussion?
Oh, I'm sorry. Is there any, thank you, Joel. Is there any discussion about the motion before us?
I
Yes.
thought that Leo had said before that this drawing was dated May 8th, and in his proposal, he said April 1st.
The
So,
May 8th drawing was the survey.
okay. So the foundation, okay. Just checking.
So I would like to add to Leo's motion that this house has to be built on this property because of the uniqueness of the village, of the surrounding area, and our emphasis on the how this home fits into the Doral Woods complex.
So let me clarify, Joel. I believe Leo's condition dealt just with the footprint. And it sounds like you're wanting to amend that and say not just the footprint, you want this house.
Yeah, I want to do what Alex said we could do, which is that we're going to approve this house being built on this piece of property. And according to Alex, we can do that if we want to.
Yeah, we can. So these elevations, not just this footprint as Leo has proposed, but these elevations, this siding, this house. That's where you would like to go.
Yes,
So you are saying that you would like Leo's motion to be amended. You would
Yes.
like to amend the motion.
yes.
Okay.
So can we specify this house or just a house that fits the character of the neighborhood?
Alex?
All right, so here's where many difficulties can arise. If you start talking about exterior materials, if you start discussing anything other than that foundation, or if you use the term character, at the end of the day, staff's going to be the ones who are going to be reviewing and issuing a permit if a variance would be granted through the day. So you set staff up to make a subjective call. Now, it's very easy if you say it's got to be this foundation submitted by this designer, this date that was submitted with this application. I would recommend shying away from colors, types of material, and saying something that is as subjective as character. What the board would need to decide is just that we hear Joel's thoughts here, his feelings, but what the five of you would need to decide is, does that foundation, does that footprint, does that preserve what you have stated in making your motion and ultimately acting on, that those standards are met and that substantial justice is achieved, or do you need to take it yet another step further? You know, if this footprint is used, then a one-story home can be built. If you say now that you've got to go with what's submitted here, then you know you're locked into that in perpetuity. So there needs to be, I feel, an opportunity for staff to make a clear objective call if it moves forward, and two, that you guys collectively decide that what conditions you impose safeguard your decision. Is that clear?
Yep, it is for me. I mean, I can live with what you just said. I can live with Leo's footprint and rely on you guys understanding when you go to issue the permit, what gets built there. That's fine.
So what my concern would be is that in turn, out of good nature on our behalf, we in turn create an additional hardship on Mr. Atkins in the property that he owns by specifying too much about what the house looks like. So that would be my only concern there, to weigh the middle a little bit.
What if we said the building footprint complies with Exhibit S, et cetera, and the structure reflects the character of the neighborhood?
I think that puts Alex in the bind that Alex was positing before. It puts staff in a position where they're having to arbitrate, is this in character or not? It puts them in a position where they're having to exert a subjective opinion that isn't really their place.
Okay.
Yeah, and my idea of character may be different than that of Cindy's, may be different of that of the neighbors in the area, or of Joel or anyone who would be making that decision. Or if I'm not even on village staff at the time of an application of submittal, then someone else has to determine that character. I would shy away, please.
Okay.
My concern is that we've spent an awful lot of time on this specific house, where the porch is, where the views are, where the windows are, where the, et cetera. And now we're about to abandon all that and let someone else come in, or someone come in and design a totally different home here. That's my concern. It just seems to me that so much of this has been predicated on this specific house. And this is what the applicant has stressed he wanted to build. Now we're going to give him permission to go build it. Well, that's fine. Then this is what you got to build. Now, if that's not acceptable, I'm not going to be stiff-necked about this. I'll go along with anybody says. I just want to point that out.
Well, I share your concern, Joel, because I feel acutely the concern of Mr. Adkins' neighbors. And I don't want to open a door to something that is going to give them an oversized eyesore in their neighborhood. So I hear you.
My concern would really, again, in turn, would be taking away the rights of Mr. Atkins and forcing his hand into the design nature of the house. And so.
Jamie, if that was the case, he shouldn't have presented this house to us.
Correct.
Yeah. And Joel, that's what I was, I'm sorry, Jeremy.
I'm sorry.
And Joel, that's what I was trying to get at when I was trying to say, if the board itself felt that this design safeguarded these findings that you're trying to make, if they were that important to safeguard these 4 reasons that you would be acting on this request, then certainly. But Jeremy's concern could be, and we see this all the time, every day in our office. There needs to be opportunities for minor variations. So therefore, there's not yet we're not back here at this stage again. We deal with it with our Historic Preservation Commission. Mr. Atkins may be going back and consulting more with his designer. There may be someone else who's interested in the lot, and there's just the roof pitches change, window orientation changes, garage door may be shifted. You really could impact things that you don't really intend to.
What I intend to impact with my vote is that you cannot come back and on the foundation footprint of this building, put up a 2-story building that's 35 feet high, and we have now approved something without considering the neighbors. I hear the neighbors, and I'm trying to accommodate them, and I'm trying to accommodate the landowner, but I sure don't want to come back and find that we approved something that is entirely different than what I can look at these neighbors straight in the face and say, I honestly believe we did the right thing by all of you.
All right, I would consider an amendment.
Well, let me ask you, Alex, before you go ahead, Leo. Would it be a workable solution for staff if we posited a condition being building a house that is reflective of the plans that have been presented as part of this record?
Right.
Is that tight enough, but also loose enough to allow you all to go forward?
I think that's a fair compromise at this point. It still would leave staff the opportunity of making a subjective kind of call. It could, but part of what we do day to day is interpret and read the meanings and uses of words. So yeah, I feel that I feel that I personally, being intimately involved with this particular case, could make a reasonable determination on that language if that was a condition.
Okay,
I can live with that.
all right. Leo, do you want to amend or do you want me to take a shot at amending this?
Let me try.
Go for it,
The original condition stipulated the footprint in accordance with Exhibit S, sheet 1 of 6, and that the building represented by sheets 2 through 6 of 6, Exhibit S, be constructed on the subject property.
And Leo, I'm sorry we're working you to death on this.
With some variation, Leo.
With modifications that would be subject to review by the planning and inspection staff when building permits are submitted.
And I think we can make it much more simpler than that. I think we can say the condition that the structure or home, however you like to put with, Julia, what was the term you used?
reflective, reflect the exhibits.
Exhibit S, sheets 1 through 6 inclusive.
And you could even stop at Exhibit S.
Beg your pardon?
You could even just stop that as Exhibit S.
I don't know what to say.
That includes the entire.
The entire
presentation,
set.
Leo, so that's
Yeah.
more inclusive.
Yeah.
You don't need to dictate, you don't need to represent the pages.
All right, is that clear?
Alex, do you have that?
Just give me 1 second, trying to capture it all.
Gotcha. Thank you, Leo.
Okay, so how about that condition of that the building is reflective of the submitted material included in Exhibit S. Does that capture it enough? Is that simple
That's
enough
good,
that
bud.
it covers it?
That's good by me.
Sheets 1 through 6 inclusive.
So we have a motion on the table made by Leo Santawaso. Do I have a second? Oh, we have an amended motion on the table made by Leo Santawaso. Do I have a second?
I'll second the motion.
Thank you, Joel. Motion made by Leo, seconded by Joel. Any discussion of this on this motion? Okay, at this time, I'm going to go ahead and proceed with the voice vote. Cindy Burnett,
I approve.
Jeremy Hooper,
Regretfully, no.
Leo Santawaso,
Approve.
Joel.
Approve.
I'm going to approve as well. So that's 4 of 5 board members voting yes, so the motion carries as made by Leo and amended by Leo. So turning to general business, didn't get a chance to last time because we continued our meeting. So I'd like to welcome Jeremy Cooper as a permanent member of the Board of Justice. Thanks for being here, Jeremy. And let everyone know that our next meeting date, if a new matter is brought before us, would be Thursday, June 4th, which is very soon. So we don't have a new matter before us. Is that correct, Alex?
That's correct. Mhm.
Okay, great. So we will see everyone then at the PNC meeting on the 4th. Do I hear a motion to adjourn?
So moved.
Second.
Motion made by Jeremy, seconded by Leo. All in favor?
Aye.
Aye.
Opposed? Okay.
Is it correct to assume that the June 4th will be at the village?
Yes, you look for some correspondence. I see that Darren's still with us, so I think Darren or I are going to send an email based on the new executive order signed by Governor Cooper. Government operations are exempt from the limit on mass gatherings indoors. So we completely understand if any planning and zoning board members do not feel comfortable coming to attend in person, and please feel free to let us know that. Staff is going to make every effort that we can reasonable here in Village Hall to have all the chairs, all the tables, everything spaced out appropriately. Items will be wiped down before and after and during if we need to take a break, if other applicants or folks need to come to speak. Doors will be propped open. So we'll do everything that we can to limit any type of contact with anything other than what you bring in person. It is for it is a public hearing for a rezoning. So you will get your packet by the end of the business day on Friday.
I have a question for you regarding your safety precautions.
Yes, sir.
Is it within your purvey to insist that anybody who enters the hall has to wear a mask?
We have not made those decisions here. That's a decision for administration. You know, right now Village Hall is still closed, and we're only meeting with customers by appointment only with a 24-hour notice to the staff member. So I do understand that there's been some communication of how we intend to phase ourselves back into an open situation, but we haven't given that a consideration yet, Joel. We can definitely start moving in that direction and see if that's what Village would like to do. But it's not within my purview, but certainly an opportunity that the Village could consider mandating.
Yeah, I'd just suggest that you ask them to do this, given the age of some of us and our medical conditions. You get 15 people in that hall. If they're all wearing masks, I'm pretty comfortable. If not, I'm not.
Understood. Thank you.
Thank you. Thank you for all you do for us.
And before we
Can I make a comment, Julie?
No, go ahead.
I just want to tell you, as a guy that's been doing this with you folks for a while, I continue to be proud of the time and effort and concern that you all have for not only the applicants, but neighbors in trying to find an equitable compromise to these situations, where there can be no zero-win solutions. And I'm really proud to be a part of this and appreciate working with you all. Thank you.
Thanks, Joel.
Thank you.
Thank you, Joe.
I was also going to say, I'd like to thank the members of the public for coming forward and participating today and putting your time in, because I know it's not been insubstantial what you've invested. So thank you. And with that, did we end up voting to adjourn? Or did you cut me off before I got there? I'll go ahead and put it to a vote then. A motion made by Leo?
Yes.
By Jeremy?
Yeah, yes, I was part of it. I can't remember which one though. Forgive me.
To adjourn, all in favor, say aye.
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 Opposed?
Thank you.
Meeting adjourned. Thank you very much for your time.
Have a good evening, y'all.